Hello, hello, hello. It's Tony McGraven coming to you from Chicago. As usual, we got some fun stuff. I got people to thank. Let me start here. Number one, Christopher Candler sent me some more Meemaw. That's pretty exciting. She's back. She's back, baby. She's got things to say. Who else do we have here? Rocky Lennon hooked me up big. They're small clips, but they are all fantastic, including a soft sit. It's short, but it's phenomenal. It absolutely is. And also, Andrea from Iowa sent me a fun one out of the 36D. But let's kick things off, shall we? Let's kick things off with the Hosack matter. Oh, yeah, I'm not making that up.
Please unmute, ma'am.
Ma'am, could you adjust your camera so we can see your face too?
Please.
Ms. Hosack, would you adjust your camera, please? Thank you.
Oh, sorry.
Can I say the words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
When I asked about the flight for recess.
Okay, November. Fucking A. Sorry about that. I apologize. I thought I disconnected.
Holy wow. That's messed up.
And then finally, I have the Heights at Dunwoody versus Brittany Berry.
She's here.
Well, she's refusing to identify herself, so unless she does that, yeah.
I haven't refused to identify myself. As I previously stated, I'm the authorized representative for that
Okay,
state.
is your name Brittany Berry?
I'm the authorized representative for that
Okay.
state.
All right,
the
Ms. Berry,
family.
we're going to be going forward on a judgment on the pleadings in your case. Mr. Williams, if you'd like to go forward on that now, we can do that.
Oh, sure, Judge. I'd be happy.
Judge Ann is all over this. I've never seen her before, but she's fantastic. You'll see.
I'll just move for judgment on the pleadings, ask for a written 7 days,
Okay,
which would be, was that 22nd?
that is going to be March 22nd.
I have an objection. A writ of discovery was filed.
I understand. I saw that your motion, you're essentially stating that the laws of this state and the country do not apply to you. That is not, that motion has no merit and it is denied.
It
Total
did not
judgment.
state that it does not apply to me.
Yep, that's fine. All right, Miss. Well, whoever this is.
In reference to the Fourth Amendment and 14th Amendment.
All right, go ahead, Mr. Williams.
Yes, sure, Judge. The total amount due to the 22nd is $2,998.28 plus costs.
Okay, and that's due from when? When was the last payment made?
Last payment was in January.
I object for the record.
Overruled. So January, what is the monthly payment?
The monthly rent in this case
Objection for the record.
Okay, you're overruled.
is $22.40 per month. There's a portion due from February.
Ms. Rodriguez, if you could please keep whoever this is muted.
There's a portion that was paid in February, and then March rent's due. That's why there's only 12/31/12 due.
Okay, so there was a partial payment,
Correct.
and this is just includes
For the
rent.
record, this is a denial of.
All right.
This just includes rent and one late fee of 10%.
I love this. This is subtle, but this comes up a lot. So they mute the people, but then you can unmute on your device. This judge knows this, and just assign somebody the task. You just keep muting them. So she comes back, but she only gets like 1 second at a time. So not only did the judge give a fantastic order with respect to how to deal with this, but her staff is all over it. It's beautiful.
Yes.
All right. All right. So that was what the order will look like. Ms. Bear, or whoever you are, I am going to remove you from the proceedings now.
Can I ask you a question?
Yes, Judge.
Why would you do this?
Now, give me one moment.
Got it.
Madam Attorney, are you ready?
This is just fun and charming.
Madam Interpreter, are you ready?
Yes, sir.
Okay, Mr. Hayner, step up one moment. Step up. Calling case number 240-561-5101, People City, Michigan versus Daniel Hayner. Sir, state your name. Hold on. Madam Interpreter, state your name.
My name is Rebecca, RebekahNzHenze.
Okay. Ma'am, do you swear or affirm you translate from English to American Sign Language and American Sign Language back to English to the best of your ability?
Yes, sir.
Can you state your certifications?
I am nationally certified, state endorsed level 3 in the state of Michigan, permitting me to work in the courtroom, Your Honor.
Okay, thank you. All right. Mr. Hayner.
Hello.
Mr. Hayner, state your name for the record.
I cannot see him.
He's in the courtroom. Excuse me, Attorney
Oh, we can
Nicholas
see
Sommer.
you.
I need to see
Yes.
the client so I could interpret for him.
Oh my goodness. Okay.
He's in the courtroom.
He's inside the courtroom.
I just like how she pipes up very appropriately. Like, what are we doing here? If we don't have visual, all of my efforts are wasted. We got to see each other. That's how this works, Judge, and he deals with it.
Yes,
Okay.
I
There was
I'll come and save the day.
Hold on. Mr. Hayner.
Which one is it?
Come on. Come.
I'm texting him right now. Yeah, he's not going to hear you.
Judge, is that a dance?
We also just have two of my favorite attorneys. You got Murad in there, who I like, and Ragnon, who's my boy. I just like him for whatever reason.
I need you to move the camera up so I can see him.
Have a seat.
I can sit in your chair.
Hey.
Okay. Can you see him now?
Can see you now, yes.
Okay. I'm going to stand behind him. Stand here. All right. State your name, sir.
Daniel Hayner.
Okay. Counsel, make your appearance, please. Oh, counsel.
Attorney Nicholas Sommer.
Okay, you're both talking at the same time. I can only
Sorry.
interpret one at a time, please.
Thank you, sir. Attorney Nicholas Somberg on behalf of Daniel Hayner. I'm present by Zoom video.
State your P number, please.
Yes, Your Honor. P80416.
All right, Mr. Ragnan.
Stanley Ragnan for the people, Your Honor.
All right, Mr. Soundbird, you waiting for my reading, stand mute?
We do, Your Honor. Thank you.
All right, court a not guilty plea on behalf of your client. Mr. Ragnan, what's the bond you're requesting?
Yeah, people are asking for $25,000 personal bond. The reason for this, Your Honor, he has 3 outstanding cases, one on 6/18/23 for police assaulting, resisting, obstructing, a case from 8/30/23 for police assaulting, resisting, obstructing, and the present.
Are those
case
pending
in front of
cases or
court.
convictions?
Pending cases. But
No prior convictions?
I don't have that information, Your Honor. I don't believe so.
Mr. Soundbird?
Thank you, Your Honor. And as soon as we found out about this warrant, he did turn himself in voluntarily. We were both in person at the courthouse yesterday. He appeared again today. We needed to wait for the ASL interpreter. So he will certainly be back in court, and I am retained. We asked for a personal
I don't
bond.
think he's a flight risk. He does come to court when required to. You're correct. I don't think he's a flight risk in this matter. Court will adopt the recommendation of the people, $25,000 personal bond in this matter. While this case is pending, you don't have to possess any handguns, firearms, or other dangerous weapons. Next court date, probable cause. Probable cause, March 28th. Preliminary examination, April 4th, both in front of Judge Sabri. Any questions?
No, Your Honor.
What time on March 28th?
9 a.m.
Okay.
Any further questions?
Is this for all his outstanding cases or just the
I just
the
called
current
one. Just the current one.
Okay, so he needs to still be arraigned on the outstanding 2 other cases then, it sounds like.
Yes. Yes.
Perhaps.
Okay. Do we want to do that today or is that a different
No,
magistrate?
I've got a rest of the docket. Whenever you can get those things turned in and get fingerprinted, we'll handle those today. But as of now,
Thank you.
I'm finished with this case, this defendant. Sir, you have a seat in the back of the courtroom wait for your paperwork.
Thank you, Your Honor. I appreciate the accommodations today. Thank you so much.
Thank you.
Thank you, Counselor.
Bye.
Okay.
Thank
All right,
you.
have a good day.
Thank you, Your Honor.
Thank you, Madam Interpreter. Thank you for your patience.
I have one simple request, and that is to have sharks with frickin' laser beams attached to their heads.
All right, and what's the next motion?
Oh,
Motion
yes.
for judge preclude use of YouTube and live streaming or video recording from any news source during the course of the trial in this case.
Any news source?
It's my understanding, Your Honor, some news agency in town is going to live stream this or intends to.
All right, I have no control over what a news
Worse than that, Law Talk with Mike is onto it now.
person will or will not do. And I've already made a ruling over, I think I previously ruled on that. I have no control over what other people do.
You can't control your courtroom, Your Honor. You can't preclude them from being in here
No, I'm not going to preclude the media from being in the courtroom. Why would I?
during the course of the trial.
No, why would I preclude them from being in the courtroom?
Because it's
I didn't catch that the first time. That is unbelievable. She just said that is contemptuous right there. You can't control your courtroom, Your Honor. She's making an argument that's okay. What she's saying is effectively, you don't want the witnesses knowing what the other witnesses say. So she's saying it's a problem that it's on YouTube because the witnesses aren't supposed to know what other witnesses are saying. And yeah, but you make a motion to exclude for this very reason in most trials. It's not bad. Judge rules against it and should. But it's not a crazy argument. But to say to a sitting judge, you can't control your courtroom is straight contempt. Wow. Meemaw's out of control. I now I don't feel bad calling her that.
my client's right. Specifically, this argument most argues Texas Rule of Evidence 614, the rule. And it's not a discretionary rule. It's mandatory that once the rule is invoked, the judge shall require the witnesses. How do we protect?
Oh, are you anticipating that people from the media are going to come in to testify?
Not testify, record or broadcast. And the point is under 614.
That was nice little see how you don't understand the rule there.
We're supposed to be allowed to have witnesses testimony separate and no commentary and no viewing of it. Every witness is able to look on YouTube to see what's going on in the court,
all right,
which means every bit of testimony will already be heard. TRE 614 is not just for language. It's about
Her real problem is she's embarrassing herself. And I'm imagining, I don't know, I'm not looking around, but I'm imagining that based upon the little bit that I've seen, that there are a bunch of YouTubers pointing that out, and she doesn't like it. That's her real issue.
About the rights of the client. And how do we protect his rights when every witness potentially has the ability to see every previous witness.
Well, the question is whether or not they actually will do that. And the other question is whether or not people who are not precluded from the rule will tell them what they've seen and heard. So that's something you all will have to tell your witnesses. They're not allowed to view anything, which is the instruction that is given to every witness who testifies after their testimony. The instructions they're given is they are not to view anything. If there was something from some news media source, they are not allowed to watch it. They're not allowed to discuss their testimony with anyone. Now, whether or not they end up discussing their testimony with anyone, does anyone really know unless they ask that question? I give the instructions and they will either follow the instructions or they will not. And if it's determined that they are not following the instructions that the court has given them, then other steps will be taken. And that'll be up to the request.
Yep, it's not ripe yet. Bring it to me when you have a violation or an alleged violation.
Of the defense counsel.
Effectively, then, Your Honor, you acknowledge that there's no guarantee that your order will be followed by either side, defense or
Well, this is what I'm acknowledging. Can you make a guarantee that if there is no media up, whenever a witness completes their testimony and I instruct that witness that they are not allowed to discuss their testimony with anyone, can anyone here guarantee that that witness is not going to discuss their testimony with anyone?
Absolutely not.
So-
However, their testimony will be available to anybody to see.
Mhm.
And that's, I believe, a denial of my client's constitutional rights and statutory rights, specifically under Texas law with the Texas Rules of Evidence.
All right, your motion to preclude media, your motion to preclude YouTube is denied.
Thank you, Your Honor.
You're welcome.
Now, Your Honor, I have a medical appointment I advised
No problem.
beforehand up at the medical center. So it's Ms. Efron's motion on the suppression. So I'm asking you to excuse now. My client doesn't object.
All right, Mr. Ruiz, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Jose Angel Ruiz.
All right, you understand that technically Ms. Conley is your first chair attorney on this case?
ma'am.
And she is asking to leave to go to a doctor's appointment. Do you understand that?
Yes, ma'am.
Do you have any objections to her leaving?
No, ma'am.
Are you waiving your right to
Hell no. I think it's the best thing possible for his case.
appeal as it relates to her leaving the courtroom during these motions?
Not sure what that means.
All right, you want to discuss that with your attorneys?
First chair is the one in charge. That's your prime trial counsel. So a lot of times people say second chaired, which means you're going in and preparing exhibits, and you might take a witness or something. But that means that's who's in charge. That's the leader.
For the record, Your Honor, I was here for the morning doc.
I'd hate to see what the second chair is like after this.
It was changed to 2:30.
All right, for the record, everyone knows the rules of the courts are this. If you are ready to proceed, you approach the clerk, have them place their file up here. No one ever said they were ready to proceed on motions, so that's why we're here in the afternoon.
She's had enough of this unprofessional stuff. Judge Boyd is doing a great job. She really is. She continues, but you can just tell that she's had days of this and she's not giving any benefits of the doubt anymore. She's like, you people are not following the procedure. And then you think it's my problem, and it's not.
At one point, Your Honor, the court told Warren Wolf not to go near the coordinator while you were taking.
While we were on the record?
Yes.
Yes. And so this is what ends up happening. And this is what the court saw. This hearing was scheduled at 9 a.m. Everyone in this court knows the rules. You've been in this courtroom before with the rules, and the rules are when you are ready to proceed, approach the clerk. They will pull your file. Your file will be placed here. I kept announcing throughout the court hearing today, hey, we are recessing exactly at 12. I said, nobody rush the court at 11:45 because we're recessing at 12. Nobody moved. People still were chatting and laughing in the box. Then I said, again, I made another announcement midday. Everyone, you all need to move with the purpose because we're recessing at 12. And then at 11:52, that's when I got an announcement that, hey, you know, you all are ready on Ruiz. That's the first time anyone said y'all were ready. Nobody ever asked the clerk to pull a file. I cannot read minds and think that people are ready when they're not. So we're back to my question, Mr. Ruiz. Are you waiving your right to appeal as it relates to your counsel leaving the court today to go to her doctor's appointment?
Yes, ma'am.
All right. Thank you.
Thank you. May I have excuse?
Yes.
There you have it. Brief mute. Brief mute. Meemaw's back at it. She's trying to get it off YouTube, and I don't blame her for that. She knows it's not playing well on YouTube. Then she's like, all right, I don't want this broadcast on YouTube. And by the way, I'm not going to be here this afternoon. I got an appointment. Okay. Well, they got a second chair. They got, but Judge Boyd does. Then she's got to protect the record on appeal for the defendant. I don't know what's going on in the substance of the case. I don't know what the charges are. I'm not going to get sucked into that case. I'm not doing it. I don't care what you people say. I'm not doing it. I've had enough fun. Meemaw's out of control. That's all you need to know about this case. Meemaw's gone rogue. She's contemptuous to the judge, and she's walking on the edge. As usual, again, this is an attorney, but I can't imagine that coming out of my mouth and not ending up in jail. That shocked me. I didn't notice it the first time when she told Judge Boyd that she doesn't have control of her courtroom. No. She's got control of her courtroom and her handbags and the flowers. All of it. All right. Thanks for coming out. I'll see y'all soon.